Good afternoon, and welcome to today's webinar. Today's topic is business interruption insurance claims. Time is of the essence. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Pamela, and I am the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you. So we ask that you submit questions. Just go click on the question button on the control panel and type your question in there. Now, please join me in welcoming McCarthy, Lebit, Crystal, and Liffman's Chris Patno. He heads up McCarthy Lebit's personal injury and trial lawyer group. A graduate of Case Western Reserve University School of Law, Christopher has been practicing law for nearly 30 years and is a Super Lawyers Ohio Top 10 attorney. Without further ado, here is Chris.
Thank you, Pamela, and good afternoon, everyone. I am here today with David Cuppage, a partner of mine at McCarthy Lebit, and the topic that we're here to discuss is business interruption insurance claims. And as we all know, there's been a lot of conversation about this subject matter out in the legal arena, the business arena, in the legislative arena. President Trump has even weighed in upon it. And what all of this has resulted in for most people is great confusion. And so what we thought we would do, David and I put on quite a few webinars and Zoom seminars on this issue, and have also created some written papers on it, is to focus on what we believe businesses should do while all of the decisions that will eventually evolve with regard to business interruption coverage make their way through the courts, through the legislative process, through the insurance industry process with regard to claims and their evaluation. And as the field evolves, as a business, what should you do? First and foremost is the concern about policies. And when we get to policies, the devil is in the detail. That's contract language that my professor Wilbur Leatherberry used to say time and time again at Case Western over 30 years ago. Insurance policies are a contract. In order for coverage to arise, there has to be a coverage clause with inclusions that sets forth what creates the coverage. So with regard to business interruption, you would have to look at your coverage clause, and typically in an all perils policy, which is the general policy most people have, you would be looking for the general area that talks about direct physical loss of or damage to covered property caused by or resulting from a covered cause of loss. So right away, when you get out of the gate, you're getting into a confusing area. And that language in most policies is the operative wording that we're focused on with these cases. You next would look through the entire policy to see what exclusions exist. And the biggest exclusion that is of essence here is virus exclusion. And we'll get into that in further detail, but there may be other exclusions. For example, if you fail to timely make a prompt notice of the claim, which is the biggest focus of this webinar today, is we want to make sure that people understand that time is of the essence with regard to making these claims. Most policies include a duty to timely notify of a claim. And in addition, when you do make your claim, you've got to make sure that the claim is broadly made for any and all coverage available, losses and expenses under the policy. You don't want to narrowly make a claim for a subset damage that may exist in the policy, but not make a claim for the entire coverage available for all losses, damage, and expenses under the policy. So to summarize, number one, make a timely claim. Number two, make a broad-based claim for any and all damage, loss, and expense. If you do that, you should be protected down the road in the future that will allow you time to determine whether you want to pursue a claim, whether you want to have a lawyer evaluate it, whether you want to go further into litigation, or what you want to do, but at least you preserved your rights. If you fail to do that, though, you may be jeopardizing a claim later that you may wish you had made previously. You also want to look at the limits section of the policy. Usually this is set forth in the declarations sheet, and there could be different limits for different losses, expenses, and coverages in your policy. When you do make your claim, the insurance company may ask you for further information. And under your policy, typically there is a duty to cooperate. What you have to be very careful with in these business interruption claims on the duty to respond is you may receive a written list of questions from your insurance carrier where they're trying to get information from you to document excluding the claim. For example, they may ask you, what evidence do you have of physical damage to your property due to COVID-19? And this can be complex for some people, and people need to realize that the policy doesn't just ask for physical damage and cover physical damage, but it also likely covers direct physical loss of use of the property. And so when answering these questions that they send to you, unless you're very skilled in insurance and claims process, it's strongly recommended that you seek advice of counsel, because the insurance company could be looking to document the reason for excluding your claim when they send you these written questions. Last and most importantly on this, make sure you have a certified complete copy of your policy in order to understand the coverages, the exclusions, and endorsements. Let's talk about politics. As I mentioned previously, we know President Trump has made a couple of statements that he would like to see business insurance covered. If it's fair, he's also made other statements. In the political arena, you have the business interests and their lobbyists against the insurance interests and their lobbyists, where the insurance companies would like to see federal immunity for these claims. They argue they never foresaw, planned for, and can't pay for such large claims. Some CEOs have sent letters to the editors and to senators messaging and lobbying for these type of claims to not be covered. When insurance agents are contacted, and some people are aware, insurance agents sell you the policy and discuss the policy, but they don't actually determine if you have coverage in the policy. The only individuals that determine that are insurance adjusters or the actual insurance company itself. So when many people have reached out to insurance agents, they've been told by their agents, well, we don't believe that there's coverage under this policy, and words to that effect. You have to look to the terms of your policy, however, because that may not be, in effect, a claim made timely to cover you. It may have been a curbside consult instead. And so you've got to be very careful to simply not rely on a communication with an insurance agent, but instead make sure an official claim and claim number is created and submitted to your insurance company. In addition to that, insurance adjusters that typically respond to these claims, other than maybe some small claims for $5,000, $10,000, or $25,000 for certain subset losses, as it relates to the business income or business generation loss, these claims, for the large part, are being denied. I'd like to move on now to damaged businesses. What do you folks say? You folks say, we paid for business interruption. We have been terribly interrupted. Some businesses have been limited in their production, restaurants with takeout service. Some businesses have been shut down completely, dental offices, elective surgeons, bars, restaurants, and those type of things. And your response is, we paid for this protection. We've waited for years to utilize this protection, and now we need you for this protection. The next group that comes into play in this are the trial lawyers. I'm one of those. And I stay in tune with what's going on both locally in the Cleveland area, throughout Ohio, as well as nationally. I'm part of a lot of chat groups and organizations that have been following this. There are individual claims and individual lawsuits that have been filed here in Cuyahoga County, as well as throughout Ohio. There's federal actions that have been filed against out-of-state insurance companies in federal court. And there are claims for declaratory judgment, which is essentially asking the court to declare that you do have coverage under this policy. Bad faith, which is when the insurance company fails to act in good faith in dealing with this claim, in paying the claim, and instead is attempting to skirt or has skirted their responsibility. And breach of contract, because an insurance policy is nothing other than a written contract between you and the insurance company, and you can file suit in state, federal court to determine this. A lot of people don't want to get into litigation right away, so they don't go speak to a lawyer. They don't want to make a claim. They just want to sit on this. Maybe you got some PPP. You want to see how all this sugars off, as we would say up in Vermont in the maple season. But you know what? You have to make sure that you comply with the prompt notice of claim and also any time limitations that may exist in the claim. The MDL is multi-district litigation. That's just fancy words for a lawyer or lawyers file suit in one court venue, and that they ask for all the other similar lawsuits across the country be brought into that court in front of that one judge, because it's more efficient to handle these things. People have filed and have asked for multi-litigation or multi-district litigation. That's pending. None of that has been approved yet. In addition to the state and federal actions of multi-district litigation, there's also class actions that have been filed. And this is a confusing thing to most non-lawyers, because when they hear that a class action's been filed, they think, oh, well, this is going to be taken care of in a class action. But what you must realize is that class actions, when they are filed, are not a class action right away. The lawyer is asking the judge to determine that a class does exist for part or all of the claims. And thereafter, the court will determine if there is indeed a class action, who heads up the class action, and what issues are going to be addressed by the class action. As it relates to business interruption claims, and as it may relate to you, if you have a claim that's worth hundreds to millions of thousands of dollars and a very large claim, lawyers and you are interested in pursuing your own claim more likely than not. However, if your business losses are in the tens to, maybe up to $100,000, depending on the lawyer's interest on a contingency or hourly related basis, a class action may be more beneficial to you if it applies. And the good thing about class actions are they help people whose damages may not be big enough to pay for a lawyer on their own, but at the same time, they also protect people who have not timely filed a claim, because the class claim would be filed against the insurance company on behalf of all individuals who fall within that class. So the class action benefit, number one, helps people whose damages may not be that large, and number two, can help people, if certified, that didn't timely make a claim on their own. Let's move on now to legislation, all right? Ohio, and it was 6, it may be more states in the legislature have bills pending where the legislative individuals who proposed these bills are asking either the federal government or state governments to come in and back up claims for business interruption, all right? So this is outside of your contract that exists in part and is within the contract in part. So for example, let's assume you have a policy with XYZ Insurance Company, and in Ohio you have House Bill 589 submitted by Ohio Reps Jeff Crossman and John Rogers. And in that bill and in other bills, they generally are asking the state or the federal government to accept these claims, even if there is this virus exclusion in the policy, and back up the claims with federal money. And there's little variances in these, but generally what the bill proposes is that the insurance company that has a contract with you, so there must be a contract, there are insurance policy limits within that contract, that the insurance company administer the claim as if it was a valid claim without a virus exclusion, that they pay and adjust and determine the damages that are appropriate within the policy limits. And for employers that are 150 or 200 or less, depending on the statute, in those situations, the insurance company would pay the claim and then could apply to the federal government to get paid back under a grant program, which is another stimulus proposal, not unlike PPP that came out. And so, you know, that, I call that the pie in the sky right now. It's discussed, it's out there, it's floating. A lot of people don't feel it has a lot of traction, but it's something that is still undetermined right now. And so you want to protect your right in case it comes to a point that you can benefit from that. Let's move on to the issue of coverages now. You see the little umbrella there, because that's what insurance is it provides coverage to you when things occur. In business interruption claims, essentially what we're talking about is direct physical loss of use of property in some form or fashion that is partial, that is complete, that is temporary, or that it is permanent. And it can be due to the actual disease itself on premise. It can be due to the disease being in the geographic area. It can be due to epidemiological studies that say that the disease must have been present, even though you can't physically show that it was present at the time, but based on science, more likely than not, it was there. You can have a second type of coverage called business interruption extension civil authority, where if the government comes in and shuts you down due to your direct physical loss and causes direct physical loss or damage, or it shuts you down due to that, more importantly, there would be coverage. You could have contingent business interruption, where, for example, if Wendy's did not get their meat because their supply line was interrupted, and the supply line was interrupted due to COVID-19. And then there's also coverage for specific peril. For example, Wimbledon this year will be canceled. And because Wimbledon bought a specific peril cancellation coverage policy that said if a pandemic or some disease process occurs, Wimbledon will not go forward. That resulted in Wimbledon getting coverage for this COVID-19 induced loss. So there's different forms of coverage that exist. There's the specific perils like Wimbledon bought versus typically an all risk. An all risk coverage is what most people have, that the policy covers them for all risks due to business interruption, due to a direct physical loss, or of damage to a covered property. Let's talk about the issue of time limits. And this is another reason why it's important to make a claim now if it hasn't been made, if you have the potential for a valid business interruption loss. There are time limits to make the claims. As I discussed, usually the policies require prompt notice. What that means is up to discussion and the court to determine, but sooner rather than later. And it's not when all your damage is complete, it's when you first believe that there is a valid claim to be made. Time limit to respond to the request for information. When they send you a letter asking for information, you just can't throw it in a file drawer and deal with it in 6 months to a year. You have to timely respond to that. You may have to gather information that may delay the process, but you need to respond within a reasonable period of time. To file suit, all right? Most of the contracts require you to file suit within 2 years as a contractual statute of limitation. However, you have to look to your own policy. It can be as short as 1 year. If there are no time limits, under the law of Ohio, you have 8 years to file a lawsuit for a breach of contract if the time limit's not set forth in the policy. But what I can remind you is that most of these policies have a statute of limitations of 2 years, many of the ones I've seen. There's also one other time limit that you have to be very aware of. Whether your policy is a claims-made policy or a claims-occurred policy is extremely important. A claims-made policy, if you look on your declaration sheet, the policy term is typically 1 year. So for example, if I had a policy of May 15 of 2019 through May 15 of 2020, and it's a claims made policy that covers only claims made during that 1 year, you must make your claim within that 1 year. If you don't, you are likely out of luck. Now think about that. If you have a claims made policy and you only have 1 year from May 15 of 19 to May 15 of 20, that only gives you a few days to make your claim. If you make your claim on May 16, 17, or 18, you've got problems on a claims made policy. And the language within the policy tells you if it's a claims made or a claims occurred. A claims occurred policy doesn't have that problem. A claims occurred policy are most policies, and they look at what point in time did the actual damage occur? Did the claim arise? And so usually you can have a claims occurred policy. The time period can end for that policy, and you can make a claim after that time period has ended under that policy because it was in the policy that was in place at the time the claim occurred. So once again, another rabbit hole and loophole to worry about. Coverage issues, all right? You've heard me say the words direct physical loss or damage to your property or surrounding property. Usually these policies put in a provision of geographic distance from your policy where the damage can occur and the physical loss can occur. The definition of direct physical loss is often not set forth in the policy, and you'll learn as the time passes with COVID-19 that direct physical loss is going to be the words that are fought over in the courts, and what those words mean specifically to each business and its loss, as well as what those words mean with regard to the extent of the loss, the damages under the loss, and the duration of the loss. The second big issue that you're going to deal with is, does a virus exclusion apply? And here we have the COVID-19 issue, and we'll get into virus exclusions, how they developed, how virus exclusions have evolved, and why simply having a virus exclusion in your policy, although it's going to be a big hurdle to get over, is not a complete fatality. You also, in addition to the direct physical loss of the business interruption claim, have supplemental coverages. Do you have additional coverages identified with specific other damage limitations? For example, cleanup, if you had a COVID exposure in your office, any expenses that you had to incur for some offices for extra PPE or cleansing supplies, signage, all the stuff that everyone's dealing with right now with their employees and their customer base. You may have specific subset coverages in your policies for those type of specific issues. So, is there property damage? That's the $10 million question here. And that's the analysis that needs to be undertaken. And, even at lunches, dinners, that's the discussion debate that occurs. What constitutes physical loss? Do you actually have to have damage like an explosion or some degree of destruction to the physical structure itself? Does corona damage property? Or is the inability to use the property physical loss? And I submit to you, that's going to be fought over in the courts for years to come in the appellate courts. And the reality is the case law across the country is pretty much all over the map on this. There are cases where, there's ammonia in the air or smoke or E. coli or other type of actual items that interfere with the ability to use the property, but don't physically destroy the property. And my strong feeling is that's where the case law is going to evolve and focus. Whether there is physical damage or not is going to be the major issue that's fought over. Insurance industry denial letters in these claims say, well, there's no physical damage to your property. Well, that's debatable in some senses, but the main focus is it's direct physical loss of the property, not damage to the property, if these claims will prevail. And I expect that is not going to be decided for quite a while right now. So as a business, not knowing what that answer is, isn't it prudent to make your claim now and at least reserve that right that you've been paying for years? Fear can be a physical loss. There's some case law that says boulders that are even at a risk of falling on your house, or a house on an edge of a cliff after a landslide can be a physical loss, because you just are at risk of being harmed if you're there in the property. So not only is physical loss an issue, risk is also an issue. You got to look to the words of the policy, because some policies say, are you at a risk of physical loss? And although ISO, the Insurance Services Office, that was created in the early 1970s to create forms for insurance companies to use, creates these forms that they then disseminate to insurance carriers, and a lot of them utilize. Insurance carriers are on their own, oftentimes, modify these ISO endorsements or create their own endorsements. So each policy has to be looked at for the specific language that applies, number one. And number two, what does that language tie to within the policy? And number three, are all the endorsements there? Because sometimes the insurance companies put together a policy, but they don't tie all the loose ends of this policy that's cobbled together over many years together very clearly or articulately. So that's what the devil is in the details means. You have to look at each complete policy, verify what endorsements exist, verify that you have all the endorsements, and then go through each to look at the specific language, the meaning of the words, whether there's vagueness in the words, and that whether they apply or don't apply. The next thing is the virus exclusion. And I've given you the example, and ISO CP 00400706 is the actual form. And what happened was with I think it was MERS, SARS, everything that was evolving over time, the insurance industry and the governments came to form an understanding from the scientific community that, a virus could occur, and if it did occur, boy, that would be bad. And insurance companies create these exclusions in order to protect against large risks that could be bad to them. And so what we had evolve in 2006 was this standard ISO virus exclusion that excludes loss due to virus that induces or is capable of inducing physical distress, illness, or disease. Well, we heard President Trump say, well, this wasn't due to a disease, this was due to a pandemic, or other words to that effect. And I expect those type of arguments to be made in court. The problem is with this ISO, it also has some catch-all language, as many of the insurance company policies do, that extends it beyond just those words. So you have to look at the exclusion, how the exclusion interplays with the rest of the policy, whether it's a standard ISO or whether it's a hybrided ISO, or if it's an exclusion that existed in 2001 for bacteria or other disease, that the insurance company chose then not to add the virus exclusion in 2006 or thereafter. One of the best arguments to be made in policies that do not have the virus exclusion, that try to include it some other way now, is that in 2006, the virus exclusion existed with ISO, was promulgated out by ISO, was available, was known. So if this insurance company did not include it, their intentional omission of it is a de facto inclusion of the coverage for the business interruption. So I know I have a raspy voice. It sounds tiring after a while. And what I'd like to do is turn over civil authority coverage and some further topics for my partner, David Cuppich, at this point.
All right, thank you, Chris. As we're going through all of these topics and all of these issues, it's very, very important to keep in mind that everyone's policy has to be scrutinized and reviewed very, very carefully. And one of the things that we've mentioned previously is you have to pay attention to all of the conditions preceding to obtaining coverage. You have to look at your policies, look at the time limits, look at the limits for issuing a proof of claim, and then also keep in mind when you have to file your claims against the insurance companies, because they're not going to just simply roll over and provide coverage for you. They're going to issue 3, 4, 5, 10-page letters denying coverage. As Chris pointed out, they're going to ask you for a ton of additional information, and it's important to get on these things right away. So we look at what type of coverage is available, and one of the first things that pops out at us is, hey, civil authority coverage ought to cover us, right? Because the Ohio Department of Health has issued a stay-at-home order. It was amended. Now there's a stay-safe order. There's all kinds of different rules and regulations from the government now that are requiring businesses to shut down. And so naturally, we look at the civil authority coverage, and we have to really scrutinize what is in those policies. Typically, the coverage exists where governmental authority shuts down a business, but that's with a caveat. There must be, typically there must be physical damage to your property or to adjacent or nearby property. We can see that in potentially the supply chain. If you have someone in your supply chain who has physical damage to their property so that you can't obtain sources to produce your product, that might trigger civil authority coverage. But again, what we're seeing is that the policy is in fact tied to property damage, physical property damage, and that gets back to a lot of the things that Chris was talking about earlier today, and that is what exactly is the physical damage, the physical property damage that we're looking at. There's cases throughout the United States that deal with those issues, cases in Ohio that deal with those issues, and so we see things, mold, asbestos, bacteria, other things that might in fact cause physical property damage. It also has to be causally related or connected to the government order and the physical damage that incurs. If the order isn't, if your business isn't shut down due to a governmental order that is directly caused to property damage, chances are you're not going to have coverage. But again, we need to very carefully review the coverage that you do have and the reasons for the shutdown, and tie the civil shutdown order to the property damage, to your property or to your supply chain's business partner's property. One of the things that is also important to say is that if you look at the exclusion of what's not covered by civil authority, just because there's, like we said, just because there is a civil authority order, a shutdown order, doesn't necessarily mean that you're going to receive coverage. If the civil authority order shuts you down for reasons unrelated to property damage, you may not be able to obtain coverage under your civil authority liability policy. We've seen these fights in courts before, after 9/11, after Hurricane Sandy, after other disasters. The insurance companies have tightened up their policies and have made it clear that the civil authority order has to be tied to the property damage. Chris mentioned before that potential fear of property damage is potentially enough to trigger coverage. At the same time, some of the civil authority orders are being issued out of fear of future attacks, fear of future pandemics, fear of actually what might take place in the future. So we have to be careful in looking at what these policies are saying, what the language is, and how that shutdown order really affects your property. The types of coverage that you might be entitled to under a civil authority coverage, which is also applicable to the business interruption policies and also applicable to the contingent business interruption policies, would be loss of business income, extra expenses that you might incur as a result of a shutdown order. And it's also important to point out that there are time limitations in terms of how long and for how long the authorities will shut you down and how long your coverage might last for. So again, it's very important to review the orders, review the policies, and pay close attention to what the policies are saying.
We've got a couple questions here, David, that I'd like to address. One of the questions was, does every insurance policy have business interruption coverage? Should every policy have business interruption coverage? My standard response is every policy should have as much coverage as you can reasonably afford. You have to look at the reasonable, foreseeable exposures to your business, and you have to reasonably cover those with insurance that you can afford as a business. Obviously, it's the same in buying auto insurance, homeowners insurance, or anything else. It's something that I would look for and want to have in if possible, if it was reasonable. But, you know, if your business can't afford it, or it's something that you don't think you have a big risk for, then it's not something that you should spend the money for. We have a second question, and the second question is about takings or action against the government for the government implementing their civil authority orders with the stay at home, shutting down elective surgeries, dental practices, bars, restaurants. You know, the stuff that has caused a huge damage here is the government action itself. And that it raises a very interesting issue. Is the government then liable under a takings cause? And a lot of people believe that, you know, that should be the case. A lot of people believe that that should not be the case. Once again, with regard to government takings, which is outside of a business interruption claim against an insurance company, there may be a valid cause of action for that. There's been a lot of discussion for that, of taking without just compensation under the Constitution. But the government's going to argue, look, we have under our police powers the duty to protect society, the duty to protect businesses for the good of mankind moving forward. That's going to be their argument, that they're immunized, that they should not be liable for taking without just compensation. But I know that that is, you know, a hotbed of litigation, not unlike business interruption, that we are likely to see into the future. I myself personally am not involved in any of those claims, nor am I pursuing any of those claims. There are only so many fights that I can get into at one time. And with that, I'll turn it back over to you, David.
Yeah, and right, and that's a very good question. And obviously, when you talk about a governmental taking, there are direct physical takings when the government appropriates your property, and there are regulatory takings or inverse condemnation takings. You're going to see separate seminars and webinars and papers on that topic, and that could probably take up an entire day. But that's certainly something that, you know, we'll be, you know, paying attention to and watching as this unfolds. So let's talk a little bit then about what are the legal principles that apply when reviewing an insurance policy. And yeah, first and foremost, insurance policy, it is a contract, and it's the court's role, it's the court's obligation to give effect to the intent of the parties as that intent is determined and manifested in the policies itself. Courts are going to examine the insurance contracts as a whole. That means it's going to read and review and consider the entire policy. And quite frankly, you know, you can see I have clients who have binders of policies that apply or may apply. And it's a daunting task when you try to read through an insurance policy to pick out what's important, what's applicable, and what's not necessarily important. And the insurance policies, if you're reviewing your policy and you see capitalized terms, you got to search through the policy to see exactly what that capitalized term means. The courts are going to get the plain and ordinary meaning of the language used in the policy, and with an attempt to apply the plain and ordinary meaning of that policy to the facts and circumstances that are before it. But there's a caveat, and that is if a provision in a policy is ambiguous and susceptible to more than one interpretation, courts are going to construe that ambiguous policy term strictly against the insurer and liberally in favor of the insured. So that's a good thing when when you are looking at your policy to try to figure out whether you have coverage for a business interruption event or a contingent business interruption event or a civil authority coverage. And then I think the next important point here is when you're looking at an exclusion, such as if there is an exclusion for a virus, the insurance policy will be interpreted as applying to that exclusion only that which is clearly intended to be excluded. So courts are not going to rewrite the clear language of the contract. They will apply coverage unless it's specifically excluded, and courts will scrutinize that which is specifically excluded. So we can then, I'm going to turn this back over to Chris to talk about virus versus disease.
Thanks, David. So when we hear the COVID-19 virus, people hear that term and they think, well, gee, if there's a virus exclusion, is there any way around that if it exists? And so we have to first look at, what are the cause or causes of the business interruption? There can be many causes. It could be you can't access your business due to a governmental authority order. It could be that you had COVID within your business. It could be that your supply chain was interrupted. So you have to look at your policy. You have to see what the actual cause was, or causes, there could be many, of your business loss. And then under the law of Ohio, unless contract language says otherwise, Ohio is an A cause. It has to be a cause to be covered. So if there's many causes and a cause results in business interruption or other business covered damage or expense in your policy, you could have coverage unless the policy itself limits it to substantial causes or other direct and sole causes. You have to also look at when did the business interruption begin? Did it begin when, Corona was first in the air in Ohio? Did it begin when the Corona appeared in your business? Did it begin when the interruption was partial, complete, when you started and then incurred supply chain issues? So that's going to be also an important issue. And what aspect of the virus or disease caused it? Now, when we look at virus, here, coronavirus is called SARS-CoV-2. And to understand that, you look at that in comparison to the disease, and the disease itself is COVID-19. So then the question becomes, what's the difference between virus and disease? Well, the virus causes the disease. So SARS-CoV-2 causes COVID-19. And you have to look at the causal language in the virus exclusion because it may interplay between virus and disease. And words matter. an insurance policy and contract language. And it gets very precise and very detailed, and that's one of the things you have to look at. Are you excluded because of a virus? Are you excluded because of a virus and a disease? Or is there causal language? An example would be HIV is a virus that causes AIDS. And, you know, the same type of thing works here with COVID. One of the messaging issues that we've heard time and time again since even began the business interruption claim debate in this country was, we can't cover this and we never saw it coming. We've heard that over and over from many in the insurance industry. And what businesses, some of them do, many of them don't understand, is that insurance is $1 trillion industry in this country. In 2018, the insurance industry had $1.7 trillion in cash and invested assets. And in 2018, that very same year, they had $49.5 billion in property losses. However, they made $60 billion in net income in 2018 alone. So when the insurance CEOs are running to the Wall Street Journal and sending letters to the editor and op-eds and saying, we can't cover this, my question becomes, well, how can the business that paid you all these premiums all these years and was horribly damaged, how can they cover this when they went to you for coverage and for help? And now that they need it, you know, the fact that you can't cover it really doesn't meet out with the science. And we knew that in 2006 with the ISO virus exclusion, they knew this was out there. And I believe personally that they made a conscious decision at that time to exclude it rather than to advise and protect their businesses, because they foresaw that this damage could be so large. So not only do I not believe that they never saw this coming, I believe that they saw this coming. They intentionally created the virus exclusions in order to allow them to continue to profit and failed to provide protection that was necessary. So I'd like to just get to damages, and then I'll turn it over to David for some final comments, unless we get more questions. So what damages exist, and what can a business do after they make their claim? The claim likely has been denied. You have to look at what the income net profit would be under most of these policies, and the continued normal operating expenses and the payroll expenses. Those are the two areas that under business interruption that comes into play. So not only is your net profit in play, but also your normal operating expenses and payroll. Well, a lot of people say, well, gee, I applied for PPP and I got that. How does that affect? Only time will tell is my response. But with PPP, the argument is you didn't lose if you get the PPP, and it is then forgiven as a grant. So there likely, in my belief, will be an offset of PPP for anyone that does prevail on a claim of this nature. You have to look at, well, was the business suspended? Was it a direct loss? Was it periodic? And then after your coverage under the original period when you were harmed, there's also in most policies a period of restoration. So this is after you're closed, but then you begin opening again. Usually there's 30, 60, 90 days of extra coverage when you restart, but your income and your payroll and whatever you typically ran at before the shutdown is still harmed, but you are at least mitigating and moving forward. Duty to mitigate. Well, you can't just shut down due to an order and then not reopen when the order is lifted, or shut down due to COVID and the cause of your loss, but then not timely do what you need to do to reopen operations. A lot of these policies will reduce your coverage for your failure to mitigate or your failure to resume as soon as practicable. Other policies have extra expenses, and the business income policy also has extra expenses typically that are covered when you have to pay to mitigate. The PPE and the cleansing devices, signage, the stuff we discussed earlier. Set off, we discussed that. So what do you do if you do get a denial letter? You can sit and wait, see what happens with legislation. You can file suit in court, or you could do nothing. The lawsuit options in court are to declare that this is a valid contract, to go after the insurance company for a bad faith denial if you believe you've been treated in bad faith or a lack of good faith. You likely would want to claim an appraisal and ask the court to order an appraisal, because most insurance policies have that. And for a public adjuster to do an appraisal, it's usually very costly, so you'd want the court to order that and the insurance company to pay for it. And then, is this something that you want to go to a lawyer and have them file a class action, file to be part of the multi-district litigation, file on behalf of you individually? Or is this something that if you are already a part of a class action, I'm unaware of any that have been certified to this point, but that you may just want to sit and wait. So that's essentially, a quick summary at 100 miles an hour of a very complex area. We're not perfect, but we tried to convey what we believe was important for you. And I appreciate your time here today. Once again, I'll turn this over to my partner, David Cuppage. And on behalf of our law firm, McCarthy Lebit in downtown Cleveland, we truly appreciate your attendance here today. And in the PowerPoint, we've got our contact information. There's many lawyers out there who are handling these claims, some with more experience than others. If there's anything we can do to help you, please let us know. And with that, David, I'll turn it over to you.
Yeah, thanks, Chris. Very quickly, the major message here today is time is of the essence, and you really do need to scrutinize your policies. I would expect to see business interruption insurance coverage and civil authority coverage in most business policies to answer one of the questions we've seen earlier. That doesn't mean that there's not going to be that exclusion as well, but I would expect to see it. Finally, you're probably already seeing this, but your premiums are going up, and as much as 15 to 20%. I've seen it range from 15 to 20%. So you're paying for it. You're going to be paying for it, and you should probably pay very particular attention to your policy. I don't know if we have any further questions.
Yeah, I just have one final comment. I know a lot of people have told me, well, I didn't make a claim because I was afraid it was going to affect my premiums. What I've been told by other people is that the insurance industry has already factored this in. So it's baked in like the stock market, where unless you have a unique premium experience, making a claim like this at this time is not something that is likely to largely affect your premium. Obviously, you have to rely on your own insurance agent's involvement and assessment of your own particular needs. But Corona's out there. Everyone knows it's out there. Everyone knows your industry has been affected, and it's already baked in, is what I've heard. All right, and with that, I'll turn it back over to Pamela. Are you there, Pamela?
Hello.
Hello.
Thanks to everybody. Thank you guys for your information today. Thanks to the team from McCarthy, Lebit, Crystal, and Liffman for sharing so much great information and insight with us today. And thanks to all of you for joining us. We hope you found today's presentation engaging and informative. If you have any thoughts to share, please let us know. This concludes today's session. Thanks again.
Thank you.
Thank you.
Bye.